Thank you, Lisa. I was going to try to move the podium forward, but I think I would knock it over, so I'll just, okay. Okay, thank you, everyone. It's an honor to be here, and I just want to say at the end of today, I think all of you, if you're not already proud of Utah, you'll be prouder of you will be proud of Utah, and what Utah is doing, what the people of Utah are doing on this issue is inspiring. I think they are really reaching out and defending the Declaration. They're defending the Constitution. They're defending the very foundations of our country, and they are inspiring movements all across the country on this issue. What's going on is complex, and my job is to kind of set the framework for what's happened. 17 years ago, progressives, and I'll use former Attorney General Ed Meese's definition of progressives when he spoke out against the Common Core at ALEC last December. He said progressives are people who despise the Constitution, who don't believe in the Constitution. So 17 years ago, a group of progressives thought that we really need national education standards. And they started with history standards, and they went with the prescribed legislative process. They introduced a bill in Congress, and people got wind of it, thanks in part to Luncheon. People got wind of it, rose up, and defeated the bill 99-1. So these people learned their lesson. They learned that if you go to the people and ask them to pass national education standards, particularly progressive national education standards, the people will say no. The people will embrace the Constitution and the Declaration. So they needed a way around that. And that way around it is the Common Core Race to the Top program. And I just want to walk through the timeline as briefly as possible on that. But when it comes to this whole program, I think it's good to read a few quotes from a few people who have opined on it. Texas Governor Rick Perry said no to this whole program right from the get-go. And with respect to it, he said it would be foolish and irresponsible to place our children's future in the hands of unelected bureaucrats and special interest groups thousands of miles away in Washington, virtually eliminating parents' participation in their children's education. And I think it was last year, a document was put out called Closing the Door on Innovation. And it was signed by, among other people, Dr. Bill Evers, who was here, and Attorney General Ed Meese. And that statement said, in part, there is no constitutional or statutory basis for national standards, national assessments, or national curricula. Even if the development of national curriculum models, frameworks, or guidelines were judged lawful, we do not believe Congress or the public supports having them developed by a self-selected group behind closed doors and with no public accountability. And then yesterday, your own Solon Institute issued a report, and I just want to read a statement from it. Their report on the Common Core said the following: Utah is at a critical decision point. The longer it waits to change course, the more difficult it will be. To maintain Utah's independence, the state should immediately exit Common Core and all agreements related to it. So this is what we have. We're talking at the core of this issue, if you will. We're talking about education standards, which are kind of instructions to teachers, and what are called assessments. Assessments are really standardized tests. And standardized tests are kind of the strong arm on the assessments. The standardized tests guarantee that teachers will teach to the standards. So what happened with this movement? It was really the flame of the national standards, national curriculum movement was kept alive by Governor Jim Hunt, the former Democrat governor of North Carolina. And he got the National Governors Association to adopt the cause. The National Governors Association and Jim Hunt then got the Bill and Melinda Gates Foundation to sign on to it, and around 2007, 2008, and they've been funding it to the tune of tens of millions of dollars a year. And basically the job of the National Governors Association and its co-partner, the Council of Chief State School Officers, and those are trade associations, by the way. Their name implies that they have a grant of legislative authority from the states, but they don't. They are trade associations. The money they get from private sources far outweighs the money they get in dues from the states, and a lot of states, some states don't even belong to those associations. So the National Governors Association in December 2008 came up with during the transition of the Obama presidency, to the Obama presidency, they came up with a plan to get the standards implemented through the Federal Department of Education. And then in 2009, the stimulus bill was passed, and that allocated to the Department of Education $4.35 billion to spend on the Race to the Top program. So basically, from this point on, you had the National Governors Association and the Council of Chief State School Officers working in concert with the Federal Department of Education. And a week after the stimulus bill was passed, Arnie Duncan went on C-SPAN, and he was asked, well, what are you going to do with this Race to the Top money? And he said, well, what I want to do with it is I really like the work that the Bill and Melinda Gates Foundation is doing in the National Governors Association in promoting national standards, and I want to be the spark that makes that happen. So that's what they used the $5 billion, $4.35 billion stimulus money for. And it's important to note that unlike the health care bill, Congress never voted on this per se. They just gave a grant of money to the Department of Education and let the Department of Education fashion how that money would be paid out. So in some respects, this was like other big federal programs where the federal government puts out money and ties conditions to it. But in other respects, it was much more coercive. It set a new precedent for kind of federal coercion. So if you remember back to 2009, there was the forecast was we're going to face economic Armageddon. The states are facing bankruptcy. They're not going to have enough money, et cetera, et cetera. The federal government stepped in and said, well, we're going to help you with this giant stimulus bill. So in the context of that, though, the federal government, with this education money, acting, I guess, on one hand like a good Samaritan, but they turned around and they said, well, here's what we're going to do. We're going to let you have this money, except we're going to provide a few twists to it. Number one, you're going to have to compete for that money. Now, that's kind of perverse to tell the states, we have $5 billion, which we got from your taxpayers, and we're going to make you compete for that money. So that was one thing. Then the second thing they said is the way you're going to compete for it is you're going to compete for it by signing on to this policy agenda we have. And you score points by telling us, by proving to us that you're committed to this policy agenda. And you have to commit yourself to the policy agenda And then there were two twists to that. They said, well, number one, you have to demonstrate to us that you're committed to us regardless of whether you win the money. And then the second thing they said is, among these policy changes we want you to make, we're going to have standards, and national tests. And we want you to sign on to those things before they're developed. And then they said, that's what happened. Then they issued the Race to the Top program by which the states could compete for this. And the timeline is also perverse. So November 2009, the first Race to the Top program came out. What was announced January 19th, the applications were due, and in the applications, the states signed on to these policy changes. In March 2010, the first draft of the standards came out. So the first draft of the standards came out after the states committed to the standards. Then there was a second round of Race to the Top, and those applications were due June 1, 2010, and again, the states committed to all these policy changes. June 2nd, 2010, the final draft of the standards came out. So the states had already committed to them before the standards were released. Then the federal government gave the states 2 months in which to formally adopt the standards. So basically, what the states had in this period of economic turmoil, with the federal government saying, we want to give you money to save your state. We want to give you money to save your state. The federal government said, you have 2 months to sit down, evaluate these standards, compare them with your previous standards, do the right thing by giving notice, presumably, to your legislature, and most importantly, bounce this off the people of your state. Engage them in dialogue as to whether or not this is something they really want to sign on to. Now, those last two things are things I added to it, right? Because that's what we do in America. That's how the Constitution was adopted. The Declaration of Independence was read out in the town squares all across the country. George Washington would read it to his troops on a regular basis. That's the tradition in America. You give the people notice. That's really what the structure of our government is for. It's about giving the people and their elected representative notice about what's going on and letting them weigh in. So this process, that was what this process was geared toward. It ties back to what happened 17 years ago with the National History Standards. This wasn't state-led. The states were victims in this. The democratic process was victims in this. That's how it came about. Now, I want to address a couple of things. When we're talking about standards, there's a lot that's said on the evaluation of standards. There's really two things that we're dealing with. One is the technical sufficiency of the standards. The other is the kind of the philosophical underpinnings of the standards. Those are different things. These standards have, in English language arts, there's a radical shift in the standards from classic literature to informational text. No one has done a study or an evaluation as to how that's going to affect students. How we go from this American tradition of studying classic literature and the importance to that to becoming a citizen able to exercise your liberties, learn prudential decision-making, learn empathy, basically becoming a citizen leader versus the European style of education. That's something that Jamie Gass will touch on. And I just want to say one other thing. I know we're short on time here. So this is the consequence of essentially turning the democratic process on its head. The consequence is the public debate is happening after the fact. That's why legislators didn't really know what this was, weren't able to conduct hearings on this. That's why the people now are just rising up about it. There's more decisions to come down the pike on this. What we've done is the standards and the assessments aren't owned or controlled by Utah. They're not even owned or controlled by the federal government. The standards are owned by the National Governors Association and the Council of Chief State School Officers. And when we talk about the governance of the standards, even pro-standards groups admit that we have a lot of problems ahead. Who's going to evaluate the standards, whether they're effective, whether they need to be changed, whether we need to add new subjects to the standards. All of that now is murky, and it's controlled by the National Governors Association and the Council of Chief State School Officers. Hopefully they'll let you all involved in the process. And then secondly, the assessments are controlled by a consortia of states. So Utah has already given up tremendous amounts of authority and control over these issues. Point being that the decision making on this is going to be more heated, more complex, and more important over the coming couple of years as these decisions have to be made. So with that, I'd like to turn it over to Jamie Gass.
Thank you, Emmett, and thank all of you for taking time out of your busy schedules today to come and listen to us.
Is your microphone actually on?
So thank you so much for taking time out of your busy schedules to come and listen to us today, and I want to thank Elisa Ellis for all the hard work that she has done to help organize a variety of very important discussions, including the discussion we had yesterday with the governor and a handful of state senators. My name is Jamie Gass, and I'm director of the Center for School Reform for Pioneer Institute, which is a Boston-based think tank. We're an independent think tank. We take no government money. We take all of our money or earn all of our money through private contributions. Former Governor Romney's former lieutenant governor and his campaign manager both serve on our board of directors, but we are a nonprofit independent think tank. I became involved with this push for national standards, or studying this push for national standards 2 years ago, because Massachusetts in the 1990s, with bipartisan leadership, with former Governor Weld and the legislative leadership, engaged in an enormous education reform effort that was a huge exchange of a great deal of additional money in exchange for all of the hard things that are in education reform, including high-stakes testing, charter schools, and standards. And think tanks and interest groups across the spectrum regarded the standards that Massachusetts put in place in the 1990s as the very best. So the American Federation for Teachers, the Fordham Institute, and others all regarded the Massachusetts standards and tests as being the best in the country. Pioneer played a pivotal role in developing those standards. And those standards led to enormous academic gains we've enjoyed over the last 10 years or so. So in the last 4 administrations of the NAEP testing, which is the nation's report card, Massachusetts was #1 in the country in all grades tested and in every subject tested. And if that wasn't good enough, we tested as a country in 2008 against some of the highest performing countries in the world. And in the 2008 TIMSS testing, we were tied for first in the world in 8th grade science. Well, I'm not here to tout all of the success that Massachusetts had, but it was really what animated our interest in this topic, because it was very clear to us that when Common Core came down the pike in 2010, as a consequence of the race to the top, that Massachusetts was going to have to give up its highest standards and high-quality testing that had correlated with huge academic gains in order to participate. So as an independent think tank, we enlisted Sandra Stotsky, who was appointed to the State Board of Education by former Governor Romney, She had played a pivotal role in the development of the standards, all the standards in Massachusetts, and then we coupled her with Jim Milgram, who is a nationally regarded mathematician from Stanford University, and Zev Werman, who's a Silicon Valley engineer. And the three of them did 4 crosswalks evaluating Common Core at every step of the way against the high standards in Massachusetts and California and Indiana and Texas and elsewhere. And what we found is that every step of the way, the Common Core was of lower academic quality in both English language arts and math to what high standards, high-performing states have. And that is incidentally true of Utah as well. Utah had very, very high academic standards in mathematics. The Fordham Institute, who is a big proponent of national standards, even they had to acknowledge that Utah had higher math standards than what Common Core had to offer. And that's what Utah has had to give up in order to participate in Common Core. So after we did the evaluations of the 4 evaluations looking at the academic quality, we move on to the next dimension of it, which was deeply, deeply troubling to us, which is that there are a variety of legal mandates by the federal government that prohibit the federal government from establishing, directing, or promoting national standards and tests. So once again, we commissioned Ken Talbert, who will speak to you in a couple minutes, and his law partner, Bob Eitel, to look at, through an independent analysis, look at Common Core and look at all the legal dimensions of Common Core and how they relate to both the policies of the Obama administration and Race to the Top, as well as the NCLB waivers. And he'll go into a little bit more detail than I will about that, but it's suffice to say that Common Core violates 3 federal laws. And so much, the quality of that research paper was so compelling, and in point of fact, that in the 20 years that Pioneer's been around, we've had a reputation for doing very high quality research, but I think that the quality of research that we did, that Bob Eitel and Ken Talbert did on the legal issues, I think was one of the finest papers we've ever done in 20 years. And George Will in March did a column on that paper citing the research and acknowledging that there are deep, deep legal problems with Common Core. So the third element of Common Core that has been of real concern to us is the cost, because 40 or 50 American school children are going to be impacted by the development of national standards and national tests. You would think that some of the proponents of it would actually talk with the states and help explain to them how much this is going to cost the states, because in American public education, the states pay for 90% of the cost of funding for K-12 education. So you would guess that they would have the courtesy of explaining to people, such as yourselves, who are going to be picking up the bill for this, what it's going to cost. But they have not done that. So what we decided to do was to, again, hire an independent scholar from Washington, D.C. His name is Tedra Barber from Accountability Works. He's had extensive experience in and around state and federal governments over the last 20 years, 25 years or so. And what he told us in a very well researched and articulated paper was that it's going to cost $60 billion, which essentially is another unfunded mandate that you as state legislators are going to be responsible for picking up. A major, major cost driver in that will be national tests and the technology that will go along with driving that national test. And that is not something that anyone is really talking about, but it will be a significant cost. We believe that the $16 billion is actually a very conservative number. It will be far higher, we believe, over time, because the reality of it is that the federal government doesn't tend to do things that are cheaper or more efficient in their expenditure. They tend to be quite a bit more expensive than even cost projections lead us to believe. So. And again, so I would really appeal to you as state legislators. We've been working with 5 or 6 states across the country. This is a movement that is getting more and more traction. There's been a lot of leadership in places like Texas and Indiana, South Carolina and Maine and Colorado and others. But I really appeal to you to take a very hard look at this. We are very confident with the quality of the research that we have done on this topic, on the academic quality, on the legality and the cost. But this is really a state issue, and it's going to require state legislators to really pick up the mantle of this kind of reform. These are reforms that have been driven really by the executive branch at both the state level and at the federal level. There has not been a bill passed by Congress that has authorized this. There have been very few state legislatures in the country that have authorized this. And I think at a minimum, the goal of public education, going back to Horace Mann in the 1830s, at a minimum is to inculcate basic principles of democracy so that our children are able to pass on our democratic principles and democratic ideals. And one of the things that we are deeply, deeply concerned about with Common Core is that it really has been developed in a completely undemocratic fashion. It's really been done by the executive branch, and it just, at a minimum, that is a very, very bad practice. So without any more discussion, I'll pass it along to Bill Evers. It's a guy that we have worked with very closely over the last several years with an enormous amount of expertise on a variety of different elements of this. So,
So, good afternoon, ladies and gentlemen. I'm Bill Evers. I'm from the Hoover Institution at Stanford. I was Assistant Secretary of Education for Policy in the George W. Bush administration. Some listening materials connected with the 2 days I'm spending here in Utah mentioned that I'm a Romney advisor for the National Campaign on Education, but I just want to make it clear that my remarks today and my remarks here in Utah are not campaign remarks. They do not have the sanction of the Romney campaign. I'm really here as a scholar who's a specialist on standards, accountability, and in particular on national standards. So when I met with the governor and the lieutenant governor and the governor's education advisor and the governor's legal advisor and several members of the state legislature yesterday, I went over the fact that Utah's math program is better than what the national standards were, and I explained that to him. In the course of that, I said that, for example, in geometry, one of the central aspects of geometry is similar and congruent triangles. So you remember geometry, you have a problem, you deconstruct that problem into various theorems that you've already learned that you can address. And one of the central things in doing geometry problems is similar and congruent triangles. Now, you may not use these in your everyday life today, but if you reach back in your memory, you remember angle, side, angle, side, angle, side. Remember that? Sort of remember that back there? So, despite the fact that this is the standard algorithm that has been used to teach this central part of geometry for a long time, the national standards, which are, I would call coercive utopian standards, have a new way of teaching this part of geometry. It's a way that's never been successful in K-12 education in any country, in any state or province, in any city or locality in the world, ever. It was tried briefly in the Soviet Union about 35 years ago, but was not successful. This method is taught to math majors in college. But this is going to be imposed on the whole country. Okay? Now, they didn't try this out in a small place first. The whole country, including Utah. By the way, the governor's education secretary, just to share with some of you legislators who may not have been there at the meeting, told us that the teachers of the state of Utah have been trained over the last 2 summers and are now ready to teach the national standards. There won't be additional need, she said, Ms. Curl said. The professional development needed to teach the national standards have been done, and so I guess these high school math teachers all across Utah are now ready to do this thing that's never been successfully done anywhere in the world. So keep your eye out for this, see how it goes. So I talked a little bit about some of the things that my colleagues have already told you about in greater detail, how even though this was not the standards, which are the list of topics, and in the case, for example, of this way of teaching this aspect of geometry, it's also teaching methods that are incorporated in the list, as well as just the list of the topics themselves. So they didn't have an origin in the federal government, but the federal government has taken them over, taken them under their wing, given them endorsement, and is spending all these millions of dollars promoting the national tests, creating the national tests, creating model curriculum, and essentially coercing the states, similar to the 55-mile-an-hour thing that was done with highway funds, into adopting these standards. So that's where we have it. They don't have their explicit origins in the federal government, but they have been brought in to the federal government. So, and when states try to defect, the Secretary of Education, for example, in the case of South Carolina, sent a, I would call a bullying letter. I think it would be a fair characterization to please get out of this. Now, there are ways that Utah can back out of this. After all, the state legislature can refuse to fund whatever costs are involved here. If you look on your table, you'll see a sheet has American Principles Project on it, and it talks about the cost. Now, the governor's education advisor, Ms. Pearl, said to us at this meeting, and the members of the state legislature who are here now will confirm what she said. She didn't think there were going to be any additional costs, but if you look at this, there's one of the sheets says, what will it cost? And so you have that on your table, a couple of copies on each table. So I don't think it's settled whether she's right or whether you should be cautious about this and whether there will be additional costs. So that's another thing to certainly bear in mind. So you gave away your control, not you, the legislature, because actually only 5 states in the country did the legislature have a vote in doing this. You gave this away, and you didn't get the money. So you didn't even get the mess of pottage, so to speak. So anyway, you don't have that, but you could try to back out of it. You could try to modify the waiver application in which the state promised to adopt the national standards as written, and where the state signed on to one of these national tests. You could try to back out of it. Virginia has been able to get some relief. Remember, you basically have sometimes people will say, oh, you're getting relief from No Child Left Behind. No, you're getting some temporary relief from some parts of No Child Left Behind. Almost all of No Child Left Behind you still have in force. You could try to regain your independence. So there are ways to do this. And I just want to stress that these sort of things seems inevitable. A lot of states have signed up for this. 45 states, 45 and a half states. But the New Standards Project was a program in the 1990s. And they had 22 states. By the time they got their test out, only 2 states were in it. And within about a year, the whole thing was gone. In 1997, 98, the Clinton people tried a national test effort. They got 6 states in on it. They signed a contract for test development. It was overturned by Congress. All the remaining items were given to Nate, the National Report Card. So that one was gone. Then Clinton had another one. He tried again later in his second term, called Goals 2000. He got 48 states under that, even more than this one under Obama. It expired 5 years later, and as the great historian of education, Morris Banofskas said, with little notice or regret. So these things sometimes look big, they look imposing, they look like a juggernaut, but they can fall, and fall hard if the people decide that they're fed up with them, that they're fed up with the federal overreach that's going on. So I I think that Utah is in a position to bring its political culture of the pioneer days and of an independent spirit to bear and say, why should we accept this inferior project being imposed on our children who deserve the best possible education they could have? Instead of this thing that was rushed through essentially in the dead of night with little or no review or notice, take it back. And so that's my suggestion of the opportunity that lies before you, but it's based on my serious expertise as a scholar in evaluating these standards from top to bottom. And I hope you will consider my remarks carefully. Thank you. My colleague from the U.S. Department of Education back in the George W. Bush administration. He was the chief legal officer of the department, Kent Tell. We're dropping pens here, and one of us is going to die rolling on a pen. There are books all over about federalism and the states being separate from and different from the federal government, and the states gaining from competition with each other. This is all going to disappear with this kind of intergovernmental cartel. This is not the system of James Madison. This is not the system of the American founding fathers. This is a federal takeover. It's a cartel with the feds leading the states. It's not what we want, people. It's not the patriotic American way.
Thanks, Bill. Before I actually start into the real content of what I have to say, I do want to lighten things up just a little bit before we eat. It appears there was a high-priced lawyer, a low-priced lawyer, and a tooth fairy, and they were all in the conference room one day. And on the conference room table was a $100 bill. As happens sometimes in the summer, when it gets very hot, you have a power surge, and the power goes off. Well, it just so happened the power went off, and when the power came back on, the $100 bill was gone. And the question is, who took it? The answer, the high-priced lawyer. Why? The other two are figments of the imagination. I am a lawyer, and I practice in the Washington, D.C. area, and our practice is focused upon education law, and we also do a little bit of employment law. But as Jamie mentioned, what our firm was asked to do was to look at several federal laws and some of the federal programs that have been enacted in recent years, and then do an analysis of those, and then let him know what sort of conclusions we might draw from it, whether any of it runs afoul of the law or not. And so we did that. And so what I want to do is to begin with our conclusion that we came to first, and then go back and briefly touch on several points that took us to that conclusion. And then as I talk about that, the second thing I'll talk about is, well, what does all this mean for state legislators, and what are some of the potential implications? So the conclusion that we reached was that as we looked at the Common Core Standards Initiative, as we looked at the Race to the Top program, as we looked at the Race to the Top assessment program, and again, that consists of the two consortia of a number of states that are developing state assessments in English and math. As we looked at that, and as we also looked at the conditional waivers under No Child Left Behind that have been much in the news recently, and Utah was granted one of those waivers, as we looked at all of those things in the aggregate, the conclusion that we came to was that all of those in the aggregate have put the country on the road to a national curriculum. Now, we're not there yet in our view, but we're getting close and closer. And what relates to that, the federal law that relates to that is, as Jamie alluded to, there are three laws. The Department of Education Organization Act, that set up the Department of Ed in 1979. The General Education Provisions Act, which is just like it sounds, it has the general education provisions and administrative provisions that apply to education programs. And the Elementary and Secondary Education Act, all of those three laws have a similar provision in it that says basically the federal government cannot be involved in directing, supervising, or controlling instructional materials or curriculum. And again, as we looked at all of these other programs, the conclusion we came to was that all of those programs in the aggregate sort of put the country on the road to a national curriculum. And I'll explain that. First, the Common Core Standards Initiative, as many of you are familiar with, it was several states that came together to develop a set of common standards. It was assisted in large measure by the Council of Chief State School Officers and also by the National Governors Association, and there were other incentives by other organizations in the private sector, and so they developed a set of common standards in English and math. And then after that, or about the same time, you had Race to the Top, which came along, which is a $4.3 billion program that gave money under a discretionary grant program to the states. States had to apply for it, so it was competitive. And there were several states that received the grants. I know Utah applied, but unfortunately was not successful in getting a grant. But nevertheless, there were a number of conditions that were attached to the Race to the Top grants, including conditions relating to having common standards and common assessments and so forth. And so that money was distributed. And there were 2 or 3 rounds of Race to the Top competitions. And then, related to that, was the Race to the Top assessment program. And again, about over $360 million was put forward by the Department of Ed to 2 consortia, the Smarter Balanced Assessment Consortium, and then what's called the PARC, P-A-R-C-C is an acronym, consortium. And these consortia are a series of states that have banded together to basically receive the federal money and then to develop assessments in English language arts and mathematics. And then later on, once standards are developed by the Common Core Standards Initiative in other subjects, science and other subjects, these assessments will also be developed in other subjects as well that will match up with the standards. And so, again, what happened is under the Common Core Standards Initiative, the first set were English language arts and mathematics. Right now, those 2 consortia, and Utah is a member of the Smarter Balanced Assessment Consortium. They're an advisory member. They were a full member, but then they backed off a little bit, as many of you know. They become an advisory member. And so, as an advisory member, obviously, you're not going to have as much influence and control as if you are, a regular full member. And so, to the extent that the consortia will be developing assessments, the role of states that are advisory members will be, I would submit, much more limited in influencing what those assessments look like. But nevertheless, the assessments and the standards will all be aligned, and the assessments are due to come online in 2014. Again, that's in English and math at this point in time. And the federal influence there was the $360+ million that was put forward. Next came the conditional waivers under No Child Left Behind that have been in the news in recent months. And in essence, what happened is the administration had proposed to give waivers if you meet certain conditions as a state. And they had several conditions, and I'm sure many of you are familiar with it, but those conditions, at least some of those conditions, including the requirement of common standards and common assessments, are totally outside the waiver statute. There's nothing in the waiver statute that has anything about that. There's nothing in any regulations. There's nothing in any sub-regulatory guidance that mentions anything at all about those conditions. And so I would submit that those conditions are done and have been done in excess of statutory authority. The flip side is, though, if you receive a waiver, obviously you're relieved from some of the onerous provisions of No Child Left Behind, and I understand that and appreciate that, but at the same time, you have these other provisions of No Child Left Behind from which you're relieved of that are then replaced by several of these conditions, again, that I would submit are in excess of statutory authority. And again, included in those are common standards and common assessments. And so, as you look at all of these things together, the conclusion that we came to is that the department, through it's $360 million that it's sort of handed out, and actually they put it forth in a competitive grant program, and these two consortia competed for it, and they received the money. That is the federal involvement, and it's indirect, in directing, influencing, controlling curriculum. And so if you have common standards that you have developed as a bunch of states working together, if you have common assessments that as these two consortia work together to develop common assessments in English and mathematics, and the consortia consist of states that have voluntarily come together. But again, it's federal money. The assessments will follow the standards, and then the curriculum will follow both the standards and assessments, such that the curriculum that will result will in effect be heavily influenced, if not directed, by the federal money that's particularly paying for the assessments. And so you'll have common assessments and standards among these states, and then the curriculum, in effect, I submit, will also be common, and it will be taken, in a sense, states will indeed lose the influence and autonomy that they had. Now, notwithstanding what people might think of No Child Left Behind and some of the provisions there that you may find onerous, at least under No Child Left Behind, your standards in Utah and your assessments in Utah were 100% developed by Utah and no other states. Now, that again raises a policy issue as to these consortia, the two consortia that are developing the assessments, and as to the states that came to develop together to develop the standards. It raises a policy issue of, do you want to be allied with other states in developing the same thing, and everybody pushing, pulling, tugging, and so forth in terms of what it looks like, and how much influence and effect do you have, and then what if you don't like something that the others want, and you get outvoted, and that sort of thing. It raises a whole host of issues compared to prior under No Child Left Behind, where, notwithstanding the problems and challenges that many have with it, you did have the autonomy to develop your own state standards in Utah and your own assessments. And again, the conclusion that we came to is all these things together have put the country on the road to having a national curriculum. We may not be there yet, but we're getting very close, or at least we may even be close to the line now, where those three federal statutes, the Elementary and Secondary Education Act, the Department of Education Organization Act, and the General Education Provisions Act, are arguably being violated, or soon will be, once all of these things come into place. Once the assessments come online in 2014 and the curriculum is developed to match up with the standards and the assessments. And so there is the federal law issue here. And again, sort of underlying all this is the whole federalism issue, what's appropriate for the federal government, what's appropriate for the state and for the state of Utah. So that's the conclusion we came to in our report. So thank you. The question was who would have standing. Standing is a legal term, as many of you know. Many of you are lawyers, I assume. The question is who would have standing to bring a cause of action under these three statutes that I mentioned. It's a good question. I would say that a state or any state that chooses, for example, not to go along with these conditions that are attached to the waivers under No Child Left Behind, I would submit that a state such as that would have standing. Perhaps parents might have standing. Again, it depends on a number of factors. Those are ones that come to mind. I mean, there is no private right of action under the Elementary and Secondary Education Act, and there's no separate statutory cause of action under the General Education Provisions Act or Department of Education Organization Act. And so you'd first have to find a plaintiff that has been aggrieved, that has suffered some real injury, in fact. I mean, my sense is that if you had a state that had suffered an injury, particularly a state that wanted to get one of these conditional waivers under No Child Left Behind, but did not wish to agree with these conditions that I would submit are in excess of statutory authority, that such a state might be able to bring a cause of action. There might be others as well, but that's what comes to mind.
So I'm not an attorney, so I'll speak freely. But I asked Michael McConnell, who used to be from Salt Lake City. He's a former federal judge. I believe he was a law professor at the University of Utah. He's now a law professor at Stanford University. And he thought that any parent who, let's say, for example, Massachusetts, you had higher math standards. You now have lower math standards, so it was an injury. Or let's take Utah. You had higher math standards. You had kids being prepared to take Algebra 1 in 8th grade. Well, the national standards have kids being prepared to take Algebra 1 in 9th grade. So you're essentially being set back a year in Utah. And your kids, instead of your thing building up to being prepared to take Algebra 1 in 8th grade, it's a whole different thing. So there's this bubble that's going to happen where your kids are going to have to repeat. That's an injury. Somebody here could sue.
Just one more thing on the injury in fact issue. Again, it's a legal term. And, any plaintiff would have to be able to marshal the evidence they need to be able to withstand a motion to dismiss for not having standing. And so you need to sort of gather data, parents or whomever it might be, to somehow figure out and determine what the injury is. Can you demonstrate that having a lower standard than you had before is indeed an injury? Do you have data that backs that up to show what the prior standards were versus the current Common Core standards? Is there any other kind of data or information, expert testimony that might help you in that regard?
Question, Representative Leader has another question. Thank you very much. I can see why the state would try and get together and create some common standards, because Utah, for example, is a small state, and developing the standards and the assessments and the curriculum is very expensive. And so being able to get together with some states to develop some and spread that cost would seem like a good idea to me. Do you perceive that unless we get into a limited compact with some other states, that anytime we try to do this, there will be a federal attempt to hijack it, so to speak, or there will be enough people concerned that we're looking at national standards? I just see from a budget standpoint, being able to get with some other states to develop this and spread that cost is actually is a benefit. I wonder if you could comment on that.
Yeah, I think that what we're increasingly learning or realizing on a number of fronts is that anytime the federal government is involved in something, the state has to be vigilant over its sovereignty and autonomy. And yes, states could work with other states to develop standards, and I think that would be okay as long as Utah was vigilant in protecting its sovereignty and autonomy. I do think we should point out, though, I mean, when we say states got together to come up with a common core, I go back to this. This was an effort of the Bill and Melinda Gates Foundation, the National Governors Association, the Council of Chief State School Officers. It was a theoretical plan, and then the Obama administration adopted that plan, very explicitly adopted it after the stimulus bill was passed. From that point on, there was a cartel, essentially, between the U.S. Department of Education and the National Governors Association, the Council of Chief State School Officers, and the Hunt Institute and Bill and Melinda Gates Foundation. They worked very closely from that point on. So the standards hadn't been drafted at that point, and they weren't in the process of drafting them. In preparation for the Race to the Top grant application, the National Governors Association called a meeting in Chicago. The U.S. Department of Education was encouraging the state boards of education to send representatives to that meeting. And at that meeting, there was a loose discussion and a signing of a memorandum of understanding that the states would work together to develop standards. So that it wasn't to say that it was a conscious decision by Utah or other states, debate among the legislature and a decision. Yes, we need to work on this project, and here's how we're going to safeguard our autonomy and our sovereignty. That did not happen. Utah signed on to this NGA effort, and then from that point on, the standards were driven by a chief, the contractor hired by the National Governors Association and the Council of Chief State School Officers. Utah's involvement on it with the other states at that point was basically, I call it suggestion box involvement.
So in terms of the cost, so I'm from Massachusetts, and we have a very highly progressive state funding formula. So we spend approximately $13,000-14,000 per pupil. Utah spends about $6,000. So if you're in a testing consortium, you're in a consortium with standards, and they can dictate to you what the standards are, and they can dictate to you what the testing is. I think it's not that far-fetched to believe that at some point down the road that they're going to dictate how much they're going to spend per pupil too. And the thing that is, as Emmett sort of touched on, the problem here is that for your constituents is that there won't really be anyone that you can go to. I mean, these are standards that were developed by 2 or 3 private trade organizations from Washington, D.C. They're not really accountable to anyone. Pioneer Institute, 2 years ago, submitted a Freedom of Information Act request to the U.S. Department of Education to achieve, to Gates, all the major players. And 2 years later, we don't have anything. We don't have any emails. We don't have any correspondence about what has been a very well-coordinated national effort. So while on the face of it, it may look like that there's an opportunity to save some money, I think that over the long haul, it's not likely to be true. But on top of that, your constituents will not be able to have any direct input. Even the state legislators or even governors, you're going to have to work in concert with 45 other states to get, plus the Department of Education, to have control over the academic content that's tested in your classrooms. And so I think that it strikes me as a very short-sighted view.
Just one additional point in response to the question about, well, maybe it is a good idea to work together as states cooperatively, deal with some of the funding issues, the challenges that states are having. The response is it ultimately becomes a policy question for state legislators and others in the state of Utah to decide with full knowledge of what the potential implications are, some of the things that we've discussed. And so I think at the end of the day, it indeed becomes a policy question, but there are implications depending on which way you go as you examine and read some of the materials and do your own reading. That there are indeed implications, and then I think there's still the overriding federalism issue that will be there.
Question.
Yes, we have a mic for you.
Real quick before you ask that question, Pamela Smith, if you want to raise your hand, she has a mic for questions, so if you'll kind of raise your hand, she'll be able to bring you in. Yes.
Okay. Possibly the only positive outcome from the John Roberts-led decision on Obamacare was that the federal government cannot use tax dollars to exhort states to adopt or expand the government programs. How can that be applied to Common Core in the way that it was, quote, adopted by the relevant states?
I'll turn this over to Kent, but I want to say briefly, I am a lawyer, so I feel qualified to talk on this. Increasingly over the last 5 or 6 years, the Supreme Court has looked at this issue, the relationship between the federal government and the states, and possible things that the federal government is doing to unconstitutionally coerce the states to make policy decisions. Last year, maybe it was 2 years ago, in a criminal case, the Supreme Court said that this federalist structure is intended in part to preserve individual liberties, and in that case, it recognized that an individual had standing to assert a defense against criminal action brought against her. And so I'll turn that over to Ken. Oh, the Roberts decision. Roberts' decision recognized that political coercion, the factors that he spoke to weren't the factors used in the race to the top. So it helps theoretically, but in terms of the facts of the case, it's distinguishable. The points of coercion were different. I think the points of coercion included this bit about the states having 2 months to decide whether or not to adopt the standards. In other words, it was the federal government saying to the states, this is your process, you have to make a decision in 2 months, and they did it in a way that cut the people out of the process. And I think the other thing the federal government was doing with race to the top, which I think was coercive, was telling the states how the states were going to accept race to the top and sign on to race to the top. I mean, that's a sovereign decision. If a state says, well, the way we're going to sign on to a federal program is the governor's going to go out in the square and do 10 jumping jacks, that's the way the state signs on to it. It can't be told by the federal government, this is how you have to accept it.
Sure. And I would just add to that, under the Affordable Care Act decision, you had, in part of that decision, you had 7 justices that agreed that the Medicaid provisions of the Affordable Care Act should be struck down. Basically, what you had was a provision that added extra requirements, as you know, onto the existing Medicaid program, and all of it as a condition of, mandated to as part of the Affordable Care Act. And the court said, well, these states didn't know when they went into Medicaid years ago that they would have to meet these additional requirements. That was not anticipated, expected, under spending clause or any other, cases that have come down over the years. And so under the coercion theory, they struck that down. And the question is, well, how does that apply to education? And one of the points that the court looked at was they looked at what percentage of a state's budget goes toward Medicaid funding. And my recollection is once you get toward 10% or more of your state funding that goes toward a particular program that the feds are involved in and so forth, that you run into a potential question of whether it's so coercive that the court will strike it down. With respect to education, again, you would look at the state's budget on education, and then what sort of percentage are the feds requiring them to do? Well, it's a little like apples and oranges because these are discretionary grant programs that are in the Elementary and Secondary Education Act. The waiver conditions don't really involve money. I mean, they do to the extent that you might save money as a result of certain provisions being waived. You might end up spending a little more as a result of conditions being attached to those waivers. But I would need to look at it further. But that's sort of my preliminary thinking, is that it's not as strong a case in education as under the Medicaid program, because Medicaid is such a large chunk of every state's budget.
So I wanted to say one other thing, though, to help clarify that, and that is that in oral argument in this case, Justice Alito posed as a hypothetical an example of coercion of education money. So, at least in the case of Justice Alito, he completely thought that this could be coercive in education, in federal aid education.
I have a question for Dr. Evers. Before I do that, I want to thank all my fellow legislators for attending this, and I want to give some recognition to constituents of mine. Elisa Ellis lives just a few houses away from me in my neighborhood. Her good friend Renee Brady is also here, and along with one other mom, they call themselves the Three Moms in Heber, Crystal Swayze. They've been spending 48 hours a day, literally, on this for about the past 4 months. And you can see an example of the democratic process of what it has led to. And I've really never seen anything like it in my life, and I'm just so impressed with them and so proud of them. I want to give them some recognition. My question, Dr. Evers, is I think that in a conservative state such as Utah, one of the reasons that this was able to be adopted is precisely because we have a group, chambers of commerce, who have come out in favor of adopting the Common Core. And I think that Governor Herbert has relied strongly on that as well. So let me ask you, when the Chamber of Commerce says this is the type of thing that we need for business, this is the type of thing that we need on a national basis, this is something that actually will help economic growth and development, will help our employability, will help our citizens to be able to be employed in other states and vice versa, and will attract more people to our states. How would you answer that sort of argument?
Well, I think, the Chamber of Commerce are not specialists on either the U.S. Constitution, which is partly what's at stake here, nor are they experts on quality of curriculum. Now, their essential insight, which is a better educated population, is a more productive education, and hiring a well-educated worker will add to the marginal value productivity that unit of labor is bringing to their firm. Fine, that makes sense. But in fact, if you're going backwards in the quality of the math, if you're actually going a grade backwards, if you're not meeting the most competitive countries in the world, Taiwan, Singapore, mainland China, South Korea, these countries all have the kids prepared for Algebra 1 in 8th grade or an equivalent situation. You can get into it if people want to get into the weeds of this. But, they're just mistaken. And I would say it's always important, and I learn all the time from people to think, yes, you're right in general, you want a more educated population, but in this particular case, you're